Hello, my name is Janneke Gerards and I'm Professor of Fundamental Rights Law at Utrecht University. And I'm also one of the directors of the Montaigne Center for Rule of Law and Administration of Justice.
Hi, I'm Stefan Kook. I'm an assistant professor at Utrecht Law School and I focus on law and technology. And I'm also a researcher at the Montaigne Center. And Janneke and I, we've been asking ourselves what the fundamental rights and privacy consequences are of the so-called Corona app. Well, in fact, as we're recording this, there is no one Corona app in the Netherlands yet. The Dutch government has invited businesses and people to share ideas about smart digital solutions, such as apps, that could help public health workers to do their contact tracing research. Many ideas have been put forward and are currently being investigated by the Dutch Ministry of Public Health. So we really can discuss the app's details. But still, there are quite some important questions that we can ask right now. Many people worry about privacy and data protection related aspects of the Corona app. What data will be collected, for what purposes, how and where will data be stored, etc. But privacy and data protection are not the only fundamental rights that are relevant here. Janneke, you've been one of the signatories of an open letter to the Dutch government that offers advice on, but maybe also a warning against using a Corona app. And it highlights quite some other fundamental rights that are affected. So maybe you can share some of your thoughts on how these fundamental rights are affected.
Well, yes, of course. I think it is important to note that our letter is mainly intended to create some awareness of the risks that are involved in using a Corona app. Of course, it seems a great idea to many people. You just install the app on your smartphone and suddenly you're able to go outdoors again. You can visit friends and family. Perhaps you can even go to a restaurant or attend a concert. And of course, we would all love that to work. But we should make sure that we don't fall victim to wishful thinking. There are many difficulties involved in developing an app like this one and asking everyone to use it. And that is what we wanted to make clear in the letter. So as for my own concerns about the app, they of course relate to the field that I do most research in, which is the field of fundamental rights law. And partly these risks are related to the reliability of the app. Of course, we would all like to think that the app is able to make perfect predictions about who has been affected by the coronavirus and who is already immune or who is still healthy but could fall prey to the virus at any moment. But we also know that the situation, in fact, is much more complex than that. We still have limited tests available. We don't know if someone who has been affected in the past could be infected again. We don't know if someone who experiences just some mild symptoms is actually affected by the virus or just has a common cold. So any tracing app would necessarily base itself on rather shaky data. And an additional thing is that we're not sure that everyone is going to use the app. And if they do, we don't know if they will do so in a correct manner. And that also might negatively affect the reliability of the app. So knowing all that, perhaps you can understand that the app may create a false sense of security. But the main question then might be how that would affect fundamental rights. Well, firstly, to give some examples, of course, it would still have an impact on our freedom of movement. It would come to depend on our willingness to use the app and the outcomes of the app's monitoring if we are allowed to move around more freely. So that's a different type of limitation of our freedom of movement than the current restrictions are, but still a limitation. And to give another example, our freedom of association and assembly might be affected. At the moment, of course, we are all prohibited from coming together with our loved ones and our colleagues. We're not allowed to attend weddings and funerals. We cannot demonstrate. We cannot throw a party. And that might change once the app is introduced. But then the right to come together will come to depend on the results of the app. And you will understand that that can be a problem if the app is not fully reliable. And finally, there might be risks of unequal treatment involved. It's the same as for many of the corona measures. They often affect low-income groups the most. Suppose that you're not able to afford a smartphone or only have an old one available on which the app doesn't run. You will then not be allowed to go outside and that can be considered relatively unfair. So that is why I signed the letter. I think we should be very much aware of all such issues if we decide to develop and use such a tracing app.
Yeah, so in this public health crisis that we're currently in, contact tracing research is of course very important, and apps and other technical solutions could be helpful in that respect. So that may be a reason for limiting the fundamental rights that you've just mentioned. So I wonder if you can tell us a bit more about under what circumstances these fundamental rights that you've mentioned, under what circumstances they can be limited.
Well, yes, absolutely. Indeed, these fundamental rights, they can be limited under certain circumstances. There must be a good reason for doing so, though. And of course, protection of public health may be such a very good reason, just like the desire to protect the economy or to allow people to go outside and move around a bit more freely. But even so, to justify all kinds of restrictions to our fundamental rights, just having a good reason doesn't allow for any measure to be taken. There are in fact 3 golden rules that must be complied with. So in the first place, restrictions of fundamental rights must be an effective means to achieve the aims concerned. So for instance, if it would turn out that the tracing app is not sufficiently reliable, it's clear that it would not really help us to protect public health. And secondly, restrictions of fundamental rights must be necessary to achieve the aims that we've set. So that means that if there are any alternative means available that would help to realize the aim of protecting public health just as much as the tracing app, such alternative measures usually are the preferable option. And third, there must be some kind of a fair balance between the interests involved. So in fact, we have to balance, on the one hand, the interest of public health and economy against, on the other hand, the fundamental rights. And knowing that the app has a huge impact on fundamental rights, we must consider if they really can be outweighed by the advantages it's said to have. So of course, that's not to say that in the end, an app is completely unacceptable from a fundamental rights perspective. But awareness of these consequences is really important to avoid that we make any rash decisions. But that's of course my perspective from fundamental rights more generally. And I'm also very curious to learn about your perspective, Stefan, which is much more that of privacy and data protection.
Yeah, sure. So I think it's first important to point out that the privacy risks that are involved are more than just the risks that are associated with data collection and data use. So the fact, for instance, that data are anonymized doesn't mean that privacy isn't at stake. Even if the data are anonymized, the apps may enable public health workers to directly contact us or send us push messages or to advise us or otherwise intervene. And that too, to a certain extent, interferes with our private lives. So I think it's important that we don't only look at these apps from a data protection perspective, but from a broader privacy perspective. And that's the perspective of government interference in our private lives. Now, if we take this data protection perspective, an important requirement is the requirement of data minimization, which entails that the processing of personal data should be relevant and limited to what is necessary for the purposes, in this case, contact tracing. So to give an example, tracking everyone's location probably wouldn't be necessary and wouldn't be allowed. For contact tracing, maybe it's enough that we record interactions between people, and that would probably suffice. And that's possible if people's devices are near each other and communicate with each other via Bluetooth, and these interactions are recorded. That is still quite invasive, of course. But my point here is that if we accept that we need this type of large-scale contact research, and if there's a valid legal basis for that, the law still requires that we do it in such a way that data privacy is impacted as little as possible. Now, other requirements are important as well, such as the requirements of storage limitation and data security. For instance, will it be possible to keep exchanges between people's devices and servers anonymous? How long will these data be stored? I would say that if the research is done, the data should be deleted or at least completely anonymized so that it may still be of use for future statistical research. But another important question is, where will these data be stored? Will there be a central database, or should data be saved in a decentralized manner? Decentralized communications and storage appears to be the preferred route here, but that in itself, especially if you use Bluetooth technology for that in itself also creates privacy risk, because if your phone is constantly broadcasting Bluetooth signals, then that can tell a lot about people as well. Now, another question that I have is, how will the Dutch government and governments in general ensure that people use these apps? Will it be voluntary? Will it be a matter of collective responsibility? And will our government leaders call on that responsibility? Or will our employers or shop owners require us to have the app installed before we go to work or enter a shop? I think if there's one thing that this crisis is also showing, is that it shows how dependent we've become on companies like Apple and Google for our information and communication infrastructure. Apple and Google they're already working on an API that allows Corona app developers to make full use of our phone's Bluetooth capabilities. And that's great, of course. If Apple and Google are not doing that, these apps won't even be possible. And from a privacy perspective, there may also be benefits in having Google and Apple control what app developers can do with our devices. But I think it also shows how closed our phones actually are. And we cannot just download the apps from the internet ourselves, but we need Google and Apple to distribute them to us. And also, to make full use of our phones and the technological functionalities, we also depend on these two central players. Well, that's maybe for another video that we can have and we can have a conversation about it at a later moment. So I guess that brings us to the end of this conversation. And Janneke, I would like to thank you very much for sharing your insights and the important points that you're making on fundamental rights in general. So thank you for that.
Well, and thank you, Stefan, for sharing your ideas on privacy and data protection. Those were very interesting as well. And of course, thank you all for watching. We hope, of course, that you will stay healthy and safe with or without, of course, the use of the Corona app.